Good morning, committee. There was some enthusiasm there. Look, you've had a couple of days off, all right? All right. Exactly. No RSs. That's unusual, isn't it? Okay, we're going to get started here. The title on the first one in your minutes is not accurate. In the agenda, excuse me. I apologize. First, we have to do some approval of minutes. And hopefully everybody's had an opportunity to look at that. I know Representative Clark has.
I'd be happy to move that we accept the minutes for March 19th and March 20th as written.
Thank you so much. Any debate on that motion? All in favor say aye.
Aye.
Any opposed? All right, thank you, committee. Okay, so I was talking about the description under, in regards to Senate Bill 1147 as amended, and that has nothing to do with the bill. Unfortunately, that was apparently in the bill tracking system. There was a mistake there, but you will see that has nothing to do with garnishment for tax payment. Okay, so just to make you aware that is not accurate. Okay, with that, we're going to dive right into this agenda. And we have Karen with us today to present both of these pieces of legislation. And Karen, welcome to the committee.
Thank you, Mr. Chairman and members of the committee. The first bill before you this morning is Senate Bill 1147. The main point of this legislation is to prevent what was commonly referred to as the evergreen clause from ever being placed into master agreements again. As such, this legislation will limit the length of any negotiated master agreement. This legislation will require that salaries and benefits in a master agreement be in effect for 1 year beginning on July 1st and ending on June 30th. All other matters may have a length of 2 years. I want to make it clear that we are not talking about teachers' annual contracts, as is widely reported each time we discuss this legislation. Teacher contracts and the master agreement are not the same things. Teacher contracts are the individual one-page contracts that teachers sign each year that commits the school district and the individual teacher to employment for the next year. The master agreement is the agreement that is negotiated between the local union and the local board and includes all negotiated items. In order for school boards to be able to set an annual budget in a timely manner, and in order for that budget to be based on the dollars that will be available for the upcoming fiscal year, ISBA's members believe strongly that master agreements cannot be open-ended and must have a term length. In addition, the members of ISBA do not believe that today's boards should be bound by the terms that were negotiated years, sometimes even decades ago. The same would be true for future boards not being bound by the terms that are negotiated today. Subsection 33-1275-1, found on page 1, lines 31 through 38, sets out that the agreements are for 1 year from July 1st to June 30th. Subsection 2, found starting on line 39, sets out the parameters for those items that can be negotiated for a 2-year term and require that at the end of the 2-year term, those items must be renegotiated rather than just added back into the agreement. Subsection 3, found on page 2, lines 8 through 10, defines compensation as salary and benefits. The ISBA made amendments to this legislation after negotiations with the IEA, and we agreed to the 2-year term for all issues not related to salaries and benefits. The ISBA has added a 1-year sunset clause to this legislation, and we hope to collect data over the next year to see what impact, if any, 1-year agreements have on collective bargaining. And finally, Mr. Chair, we have made this bill retroactively effective to November 21st, 2012, to ensure that any master agreement that was reached during the last year remains in effect until a new agreement is reached between the parties. This bill is presented in conjunction with the Idaho Association of School Administrators. We would ask that you send Senate Bill 1147 as amended to the floor with a due pass recommendation. With that, I'll stand for questions.
Thank you, Karen. Questions for Karen? Representative Ward Engelking.
Thank you, Mr. Chairman. And Karen, I'm looking at this, and it says 1 year for all direct and indirect costs to the school district's budget. I'm thinking that includes almost everything, professional development, class size, curriculum. I mean, I'm trying to figure out, I guess, what wouldn't be an indirect or direct cost.
Karen?
Mr. Chairman, Representative Ward Engelking, I think if you'll look at the amended language, that sentence has been removed. I think if you'll look at the codified language, that sentence, or the engrossed, thank you, language, that sentence has been removed.
And so what stays in place
Follow
for
up?
2 years then? Oh, sorry. Excuse
That's all
me,
right.
Mr. Chair.
You're
Sorry.
fine. Go ahead. Follow up.
Again, the only things that must be negotiated every year are salaries and benefits as defined. And then everything else can be negotiated every 2 years.
Okay, thank you.
Okay. Any additional questions for Karen? Representative Clark.
Thank you, Mr. Chairman. Morning, Karen.
Good morning.
Which comes first, the master agreement or the teacher's contract?
Karen?
Mr. Chairman, Representative Clark, the master agreement.
Follow up.
Go ahead.
And then from that, the individual teacher contracts are negotiated or let?
Karen?
Mr. Chairman, Representative Clark, the teacher contracts are really not negotiated. They're just issued. They must be issued by July 1st. Now, understand also that school districts, especially for continuing contract teachers, can issue letters of intent, and they can do that anytime in the spring to let teachers know that they're going, and it doesn't just have to be continuing contract, but they can issue letters of intent in the spring, letting the teacher know that they will have employment for the next year. Then the master agreement is negotiated, and the teachers' contracts are then issued after the master agreement is negotiated.
Mr. Chairman,
Representative Van Orden.
I don't know if we have a copy of the engrossed bill, do we? Yeah. Is this not a copy of the engrossed bill, or?
According to our secretary, it is. Representative Van Orden, why are you thinking it's not?
Well, the numbers were a little bit different, I think, and
And Mr. Chairman, I apologize. I did not clean up my testimony, so the lines may not
Okay.
be the same since it's been engrossed. My apologies for that.
okay. Is that okay? Okay, thank you.
We okay now? Representative Clow?
Yeah. Well, my question was, I was trying to find what Representative Ward Engelking was reading. She was apparently reading from not this sheet, or
The SOP.
oh, okay, all right, thank you.
Okay. And that's possible, the statement of purpose, but the statement of purpose never becomes law. Okay, thank you for those questions. Representative Ward Engelking.
Thank you, Mr. Chairman. And Karen, I have one more question. Well, maybe two. What is the kind of general rule of thumb length for a master contract? I mean, how long, how big a deal is this, a master contract?
Karen?
Chairman DeMorna, you're talking about the master agreement that we're discussing here. Well, again, in the past, there was no time frame. They were evergreen. And so now they will be 1 year from July 1st to June 30th.
Sorry.
Follow up?
Follow up, yeah. I'm talking not the length of time to negotiate it. I'm talking about how many items are in a master contract, how detailed, how big a contract that is.
Karen?
Chairman DeMorna, Representative Ward Engelking, that varies by district. This might be a better question to Representative Horman or Representative Van Orden. They may know what their own contracts used to look like prior to Students Come First. I mean, some were small, some were many, many pages long.
Okay, follow up?
One more question,
Go
Mr.
ahead.
Chairman. Thank you. So we've got a time frame of June 10th to negotiate an entire contract. And if I remember correctly, I've seen the contracts in my district. They're quite lengthy. Is that a doable process?
Karen?
Chairman DeMorna, Representative Ward Engelking, first of all, that bill hasn't passed the Senate yet, so we don't know if that June 10th date is going to be in place. But yes, we believe it's doable.
Okay. Representative Nielsen.
Thank you, Mr. Chairman. Karen, you made a statement a minute ago that there would be some things that would be negotiated every year, and then every other year, everything else would be negotiated. And I'm wondering what you're talking about when you say everything else would be negotiated. Do we have an evergreen clause in there somehow, some way, when you say everything else will be negotiated, or is the only thing we're ever going to negotiate is compensation and benefits?
Karen?
Chairman DeMarnott, Representative Nielsen, compensation and benefits must be negotiated every year.
Okay.
And other things are things like the calendar year, the length of the day, recess duty, lunch duty, how many students you need before you get an aid. All of those things could be negotiated every 2 years.
Just to follow up.
Go ahead.
Now, you mentioned how many students to get an A. What are you talking about there?
To get an aid.
Oh, an aid to help with the class.
I'd like them all to get A's too, but
Well, that comes with age and a dumb hearing aid that's not working quite right, I guess. But so we're not ever going to be negotiating class size and those types of things in the master agreement as we have done in the past then.
Karen?
Chairman DeMarnott, Representative Nielsen, they certainly could if the school district wanted to negotiate those things at the local level. Absolutely.
They can, okay. In other words, Mr. Chairman,
Go ahead.
but they would have to be renegotiated every year. They're just not automatically in there from one year to the other without renegotiation.
Karen?
Chairman DeMarnott, Representative Nielsen, every 2 years.
Every 2 years.
Yes.
Thank you.
Okay. All right. Committee, seeing no more questions. Karen, thank you for your testimony. We have several people that have signed up to testify on this. We will start with Rob Winslow. Rob, welcome to the committee.
Thank you, Mr. Chairman. And my name is Rob Winslow, the Executive Director of the Idaho Association of School Administrators. And as Karen mentioned, we are standing with the School Boards Association, and our superintendents would find this fully support 1147 as amended, and look forward to having this pass as a good tool in negotiations. And with that, I'd stand for any questions, Chairman.
Okay, thank you, Rob. Questions for Rob? All right, thank you for your testimony. Next, Paul Stark. Paul, welcome to the committee.
Good morning. Thank you, Mr. Chairman, members of the committee. My name is Paul Stark, General Counsel for the Idaho Education Association. I'm standing for my organization in opposition to Senate Bill 1147. There's two reasons for this. There's both substantive objections to this bill as well as procedural objections. First, let me speak to the substantive objections. The primary substantive objection to this is that it robs local school districts of their local control. This is a top-down mandate coming from Boise that is mandating what they do at the local level. Even when a local school board desires perhaps to make an ongoing agreement, maybe for certain provisions, they don't want to have to go through the hoops of negotiating these annually or biannually. They are forbidden from doing that. This is, I need to note too, there's nothing, absolutely nothing in current law that requires, that mandates a school district make ongoing agreements, multi-year agreements. It's always been by mutual consent. And so there's nothing at all that mandates this. They're not in a corner. The school boards aren't in a corner where they have to do this. In fact, with the laws that were repealed last year, everything reset. So to the extent there were these quote-unquote evergreen clauses, these multi-year clauses, they all reset. So none of those are in place right now. And to further explain, an evergreen clause merely said why we're negotiating new terms, we're going to maintain the status quo. That's what it meant. We'll maintain the status quo while we negotiate new terms. It's also worthy to note that in current law that we have today, there's nothing that forbids a school district from negotiating every item every year. They can do that right now. And so, in essence, what I'm trying to tell you is current law as it exists right now does not require multi-year agreements. And it doesn't forbid a district from saying, hey, we want to negotiate everything every year. So everything that Senate Bill 1147 does, you can already do right now. You don't need this top-down mandate to say, local boards, you have to do this. You don't need that kind of mandate. They can make their own choices. I should also note that in the School Board Association testimony, there was the argument's been postured about, well, we don't want to bind future school boards. We don't want this year's school board. But in essence, that happens constantly and often in government. Certainly the state of Idaho will sign multi-year contracts. Many government agencies will sign multi-year contracts. City councils are, to a certain extent, contractually bound by the decisions of prior city councils. This is not an uncommon event. And in essence, our substantive objection to this would be to allow the local board to make their own decisions, to allow them, if they choose to negotiate every item every year, let them do it. If they choose to say, hey, some items are a no-brainer and we don't need to rehash or replow this ground every year, let's just put it into the contract and allow it to stay there until such time that someone objects to it and they want to open that up. That is always an option. Let me move on to the procedural problems with this bill. Procedurally, it is a little disconcerting on page 2 that on line 5 through 7 that we're seeing a cut and paste from the repealed laws. Again, I've said this before, and I'll ask this body to recognize the voice of the people last November and not just cut and paste the repealed laws back into existence. But more importantly is in page 2, line 25, and this is section 3, this is the emergency clause. There is a very fundamental problem with having this law retroactively dated to November 21st, which is the date that the repeal of the old laws went into effect. There's a very important constitutional problem, and I'm asking this body to respect the Idaho State Constitution. If you want to look it up, it's Article 1, Section 16, and it says, quote, "No law impairing the obligation of contract shall ever be passed." What this is saying is that the legislature constitutionally is forbidden from nullifying contracts. By putting a date in here, making this law retroactive to November 21st, there are agreements that are being nullified by this legislation, and it's violative of the Idaho Constitution. And for these reasons, we ask you to hold this bill in committee. I'll stand for any questions.
Thank you, Paul. Questions for Mr. Stark? Representative Nielsen.
Thank you, Mr. Chairman. Paul, I'm interested in knowing what contractual arrangements this is going to be canceling by making it retroactive to November 21st. Can you give me some examples of that?
Paul?
Mr. Chairman, Representative Nielsen, I will try. I think I didn't draft the language to make this law retroactive. You might ask the bill sponsor about why it was made retroactive and what they're trying to achieve. It appears to me obvious that there's some concern that there may be an agreement in effect already that by this legislation we're attempting to nullify. I am aware in a couple districts where memorandums of understanding, MOUs as they're called, were signed by school districts, jointly and mutually voluntarily signed by districts and their teachers, that said if the laws were repealed, we're going to put back in place the former master agreement. Now remember, this was nothing, no one's arm was twisted on this. This was something that was mutually agreed to by the district and the teachers. I am aware, I believe in 2 districts where those MOUs exist. I can only hypothesize that this retroactive November 21st date is trying to kill those agreements. But I didn't draft this language. I'm not sure what end it was drafted to. But I need to tell you that if there are existing contracts that were entered into after November 21st, and this law kills it, it will violate the Idaho Constitution. That constitutional provision called the contract clause is in the U.S. Constitution as well as the Idaho Constitution. It's been well litigated. There's tons of case law on this. And you can't, it's similar to, in the criminal context, an ex post facto law. You can't after the fact make something illegal. Similarly, in contracts, you can't after the fact nullify a contract between parties.
Follow up.
Go ahead.
It's really not a follow-up question to a different matter. Paul, when you state that this opens up renegotiations on everything and it's a top-down force mechanism, may I suggest this, that those areas that the school district doesn't want to renegotiate and the parties they're negotiating with are in agreement, that's a simple matter even under this law, that they could say, we agree to keep like it was last year, and that's the negotiation, that's the end of the deal, and therefore I don't see where saying they got to look at it again constitutes a great problem, because both sides can just simply sit there and agree to what they had, and that's the end of the negotiations, and it carries forward. Cannot that happen?
Paul?
Mr. Chairman, Representative Nielsen. Yeah, I suppose that potentially can happen. Frankly, I haven't sat at the bargaining table. That's not the type of work I do. But I don't know if it could really, in every instance, be distilled down to that simple of a process. Some of these agreements contain multiple provisions covering a multiple of different areas, and I would need to. I imagine you would need to speak to someone that sat at the bargaining table to see how feasible that is.
Just the following comment.
All right, comment.
In my mind's eye, this simply means that if the school board trustees want to negotiate it, they can. But if they're happy with what's been going on, they can suggest that they're happy with it. Then if the other side is happy with it, it's over with. It just means they're going to look at it every 2 years instead of not looking at it. That's all that really means to me. There still can be that negotiation, and they can agree on it quite quickly and be over with it in a moment or two. It doesn't have to be a long, protracted type of a negotiation setting, only if both parties are not in agreement to what's been going on. Would it cause any problem? And I feel they should have the opportunity to do that instead of not being able to do it under current law.
Paul, that was more of a statement. Did you want to comment on that?
Just briefly, Mr. Chairman, thank you, Representative Nielsen. All of what you're describing, Representative Nielsen, can occur right now. And so this law is at best superfluous, and at worst creates permutations that were not intended. What I'm advocating here today is allow the local district to make these decisions. And you don't need a new law to mandate certain things. If they choose to negotiate every item every year, that's their choice. Allow them to do that. If they choose to say, this is an important thing, we need to study this to see if it works, and we need to make sure that this is in place for a 3-year period, then allow them to do that. Allow the locally elected, locally chosen school boards to make that decision. Don't mandate it through a law, a statute. And that's what I'm advocating.
Thank you. Paul, I'm struggling a little bit with this local control argument, because this legislation is being brought to us by local people, actually, the School Boards Association. So wouldn't this be, you just using your own argument there, the locals have brought this legislation. So doesn't that really fly in the face of your argument in terms of local control?
Mr. Chairman, I don't believe so. I am aware that a good portion, maybe not a majority, but a good portion of the School Boards Association membership voted not to bring this. There was resolutions passed, I think, literally a week or a week and a half after the election in November, in their their assembly. I'm not sure what it's called, and I think it was a good at least 25 to 30% of their membership voted against bringing this. So I don't think it's unanimous that the school boards want this. Further, I'm told that the voting in the School Boards Association is weighted in certain respects for whatever reason, and I'm not into their bylaws, but I'm told that it's weighted. It's not a one person, one vote type of situation. But I know there were 919 votes cast against bringing this legislation. Those districts that want this can do it. everything in this law, if a district, if the Meridian District or the Boise District or the Kootenai District, whoever would like this can do it right now. So this isn't a tool that they're without. They have this tool right now and can do these sort of things. So allow them and allow the 919 votes that voted against this to make their own decisions locally.
All right, thank you. Representative Ward Engelking.
Thank you, Mr. Chairman. Thank you, Paul. Having been involved in negotiations, I know the process is that you sit down and you decide with the other team. You have two teams, and they do decide what they're going to negotiate that year. So I understand that, and I'm trying to see so the current law allows us to do that. This law, can you just talk us through one more time what this would do as far as making a change that makes it more difficult for school districts who want to keep the same thing? And I guess I'm saying that because I've talked to Boise School District, and they like it the way it is. So can you talk to me about how this will make it more difficult?
Paul?
Mr. Chairman, Representative Ward Engelking, if a district wants to negotiate every item every year, they can do that. And there's absolutely nothing that prohibits them from doing that right now under current law. If a district, in their wisdom, chooses that maybe a particular item, they'd like to extend it, it's by mutual consent, then they're allowed to do that also. What this law does is it ties the hands of a school district. Essentially, it's saying we, the legislature, know better than you do, and we don't, essentially, we don't think you should have that authority to make something more than 2 years. And certainly on salary and benefits, we don't think you should ever do that more than 1 year. And so we are more wise than you are at the local level, and we can make these decisions for you. And in our wisdom, as the legislature, we believe that at most a 2-year agreement is all that you can handle. And so what it does is it creates a tying of the hands of a board that may, for whatever reason they have at the local level, they're tied from doing anything further than 2 years in any event.
Follow-up?
Yes, thank you, Mr. Chairman. Having worked in Boise, and numerous times we were under a 3-year contract or a 4-year contract for salaries, and that contract worked out very well for the school district. There were times when I was pretty upset about it because our team negotiated a 4-year contract, and it was very advantageous to the school district. They knew exactly what their expenses were going to be. They could plan ahead. They could budget accordingly. They could plan levies based on that. So this would mean that that they could no longer do that. There could not be a 4-year salary package put together. Is that correct?
Mr. Chairman, Representative, that is correct. Salary and benefits, as it's been defined, could in no instance ever exceed 12 months. Any other thing could in no instance ever exceed 24 months. And if I may comment, not too long ago when I was in private practice, I negotiated leases for clients. And it was always a little bit of a tension because you had no idea what the market was going to do. And so oftentimes you would want to lock in a 5-year lease because you got a pretty good rate. That could benefit you later, or it could come back to haunt you later. But everyone had their eyes wide open. Everybody's represented by counsel, and everybody makes the best choices they can. Oftentimes, I believe it would be in a school district's best interest oftentimes to lock in terms. In addition to, it provides some stability and predictability in the workplace, which is important. It allows you to go on to the more important things.
Any other? Representative Van Orden.
Yes, Mr. Stark, thank you. If you went into negotiations and we didn't have this, and there was an issue or an item in the master agreement that the local elected board wanted to remove, and no agreement was reached on that, that would stay in the master agreement. Is that what you're saying?
Paul?
Mr. Chairman, Representative Van Orden, only if there was negotiated this evergreen clause, as they call it. The evergreen clause, and it's thrown around a lot, but essentially what it means is while we're negotiating, we maintain the status quo. In other words, until we come to new terms, we're going to maintain that for stability and predictability and other good business reasons. So if there was a clause such as that in there, then the status quo would be maintained during negotiations until new terms. If a clause was not like that, and currently I believe every master agreement in this entire state does not have that clause because they were all eliminated in 2011, then what would happen would be the term would expire at the 12-month or 24-month mark or whenever the term expires. And so let's say you had an agreement about insurance. At the expiration of that agreement, the insurance agreement would end. And so that's the two situations. I don't know. I hope I've answered your question. I seem to have gotten in the weeds a little bit.
Follow up. So if we don't have this legislation, we are on an evergreen. Is that correct?
Follow up?
Yeah, very good. Mr. Chairman, Representative Van Orn, no, I think that's incorrect. You would have to have an actual evergreen clause in the contract. And again, the evergreen clause is a paragraph that says, while we're negotiating, we maintain the status quo and the old terms will stay in place while we continue to negotiate. If such clause did not exist, and what I'm telling you is they don't exist in any agreement right now, there was a reset button hit to all the master agreements, then upon the expiration of the master agreement, all the terms contractually expire at that point. Everything goes to nothing at that point. There is good reason for an evergreen clause, but right now it does not exist in any contract in the state of Idaho, and it will only get back into the master agreement if the board decides to.
Okay, thank you. Representative Agidius.
Mr. Chairman, actually, my question would be for Karen.
Okay, she'll have an opportunity to close.
Okay, thank you.
Thank you. All right. Seeing no more questions, thank you very much, Paul.
Thank you, Mr. Chairman.
Bert, I can't tell. Is this a 9 or a 7 at the end of 11?
It's a 9.
Is it? All right. I just want to. No, it's fine. I just. Yeah. Excellent. That's all we have signed up to testify. Is there anyone here that would like to testify? All right. Seeing none. Karen, you're welcome to close.
Mr. Chairman, I'll just be glad to stand for any other questions.
All right. Representative Agidius.
Okay, bear with me and my thick head as I'm learning that term from my friend down the way here. So really, truly, Karen, correct me if I'm wrong, negotiation is the key word here on these master agreements with the evergreen clause. Those really have to truly be renegotiated to change any part of them where the contract that is done on a yearly basis is an absolute. Is that correct?
Chairman DeMornant, Representative Gideus, when you say the contract is an absolute, the teacher's contract is a one-page contract, and that's issued by, and it has to be on a form issued by the superintendent of public instruction. So everybody's got the same contracts around the state, and it refers to the master agreement in there. But yeah, that teacher contract is a one-page agreement that everyone signs every year that compels them to employment for the next year.
Follow up, Mr. Chairman.
Go ahead.
So the items that are in the master contract are things that you will look at every 2 years. And why is it that Paul believes that you can already do this and you don't think that?
Paul? Karen. Man.
Your tie.
Am I half awake here? I apologize. Karen.
Chairman DeMordaunt and Representative Gideus, Paul is correct that under Students Come First, all of those master agreements that had the evergreen clauses in it went away. There were some school districts around the state that negotiated MOUs that said, we would revert back to the old agreement, or we would add things back, or we would open up. That's what those MOUs said. What we're trying to do here is protect into the future. I think this is all fresh enough in school boards' minds today that they probably wouldn't do that. 10 years from now, when this is all forgotten, I'm not so sure. Because I can tell you that the agreements that we had in place prior to Students Come First going into place, and I think Representative Horman's school district was probably one of the ones that had one of the bigger agreements, several pages, 50, 60 pages worth of agreement, master agreement. And Representative Van Orden was right. Under those agreements, in order to remove anything from those agreements, both parties had to agree. And so the reality was nothing ever came out because nothing could ever be agreed upon. And so what we're trying to do is protect that from ever happening again in the future.
Okay. Representative Harris.
Thank you, Chairman and Karen. Paul mentioned an issue with the retroactive piece, perhaps nullifying agreements and perhaps being creating a constitutional issue. Do we have an AG opinion on this? Have we gone through this and seen what that might affect?
Chairman DeMoore, not Representative Harris, we don't have an AG opinion, but the language was recommended by the AG that we retroactively date this piece of legislation to November 21st. And I think the reasoning behind that was on November 21st, when the laws went back to what they were before Students Come First, we had a question about whether or not that impacted those agreements that were out there as well. So did that mean that the agreements that were in place went back to the old agreements? And so in order to protect that, the AG said, well, just make this retroactive to November 21st so that whatever agreement was in place then would continue on until and hopefully when we got this legislation passed.
Follow up?
Follow up, thank you, Chairman. Do we think this creates a constitutional issue, and why or why not?
Karen?
Chairman DeMoore, not Representative Harris, I don't believe it does, but again, I'm not an attorney, so I don't know that I can answer that question.
Okay, Representative Ward Engelking.
Thank you, Mr. Chairman. Karen, I'm totally confused now. What I think I heard you say is that the evergreen clause is not in effect right now, and that what you're trying to do is make sure that local districts don't put things in their contract that will stay in place longer than 2 years, even if they want to. Is that correct?
Karen?
Chairman DeMoore, Representative Ward Engelking, that's what this legislation would do. That's correct. And if I could just clarify right quickly, I know Representative Ward Engelking said that the Boise School District wanted longer than that, and I may be confused, but I believe during the listening hearings they stood in support of this legislation. I believe that one of their board members stood in support of this legislation when she testified.
Right. Representative Horman.
Thank you, Mr. Chairman. Karen, are you familiar with which two districts have the MOUs?
Chairman DeMoore, not Representative Horman, I believe they were Twin Falls and Coeur d'Alene.
Okay, and
Follow-up?
Follow-up. Actually, a new question.
Go ahead.
Thank you, Karen. I would humbly suggest that the IEA doesn't have unanimous agreement on all of their issues either. But if they get 50% plus one, whatever they say goes for all those teachers in that district. I apologize that I have forgotten what the weighting is. I remember there was a time when I was in the leadership when that was altered by the body in their bylaws, and I have just forgotten how that works, if you wouldn't mind explaining that.
Sure. The School Boards Association does have a weighted voting system, and it's based on 10 different strata. So the strata are based on student population, and I think it starts from 0 to 500 students, then from 501 to 1,000, and then it goes up to, the larger school districts. It is right that it is not representative of the student population in the state, and that was done purposely. And the reason for that was they did not want the 4 or 5 large school districts in the state to be able to outvote the other 105 school districts simply based on student population. So it's based on 10 different strata, and then each school district gets so many votes based on what strata they land in based on their student population.
Well, yeah, thank you. So that's jogging my memory. I think we did a study at the time we made that the vast majority of school districts in the state were under 1,500 or 1,000 students at the time, and so there was great concern about representation statewide. Is that accurate?
Chairman DeMornott, Representative Horman, that's right, and I wish I had it because I don't have it with me now. I just took it out of my bag this morning, to be honest with you. But we did look at that, and I think there were like over 75% of the school districts fell under a certain mark in our strata, and so that's why we looked at making sure that those smaller school districts had an equal vote with the larger school districts.
Okay. Thank you.
Representative Ward Engelking.
Just a comment, Mr.
Go ahead.
Chairman. I have been in contact with the Boise School District and the board, and I have not heard any support for this bill, just to make that clear. Thank you.
Okay, thank you. Representative Van Orden.
Thank you, Mr. Chairman. Karen, just to follow up on what Representative Ward Engelking said about the agreements. So if you had an agreement that you agreed on this year and it went through the 2 years, is there anything that prohibits a school board from saying, and with their local education association, that we want these same things back in the master agreements that we've had for the last 2 years? There's nothing that prohibits that at that point, is there?
Chairman DeMornott, Representative Van Orden, no. If they both agree at the end of 2 years, then they could just readopt those items.
Representative Horman.
Oh, sorry.
Okay. Representative Clow.
Yeah, Mr. Chairman, my question is this. As I look at the bill, I see kind of two issues. One is kind of trying not to lock in school districts with long-term financial commitments that they may not be able to live up to because of change in economic, and then also the evergreen clause. And so I think about what I've heard today, and is there another way to write legislation and say you can't have an evergreen clause and just address it directly instead of just saying 1 year, 2 year?
Karen?
DeMornott and Representative Clow, I'm not sure. We haven't, really gone down that path. The resolution that we have really was specific to 1 year agreements, so that's the legislation that we brought forward.
Okay. All right. Representative Van Orden.
Thank you, Mr. Chairman. I would move that we send Senate Bill 1147 as amended to the floor with a due pass, please.
Okay, thank you. Debate on the motion. Representative Horman.
I would just like to speak in support of the motion. To Representative Clow's point and earlier points, whether or not we have the clause, we have the effect. Because, as has been stated here, both parties have to agree in order to remove something. And I could cite case after case in our agreement. I will give only two. For years, the entire time I was on the school board, until Students Come First came in, we had terms that said elementary school teachers worked 7 hours, middle school teachers worked 7.5 hours, and high school teachers worked 8 hours. When we were trying to do things like do early release so we could provide collaboration time, contractually, we couldn't do it. Even though it was a good thing and all the research said this is where you need to go and this is what you need to do, and because both parties would not agree to that, we couldn't change it. Well, it's changed now, and it also created disunity among our staff who some people had a contractual obligation, and I know teachers put in a lot more than 7 or 8 hours during the school year. But contractually, there was an inequity there. And because both parties wouldn't agree, we could never alter that. There was also specific language in ours about the use of data, which is crucial to continuous improvement. And again, that was locked in there, and we couldn't do it. Now, under federal law, or under the term, I should say, of our ESEA waiver, we have to use data. And so I list those as only two examples where even if the clause is absent, the effect is there, and it does bind future school boards from addressing community concerns sometimes, research, and not to mention current economic conditions as we have been under. And both parties can, as Representative Nelson mentioned, agree quickly to put something that's working for both parties back in. And I have experienced that as well. I have been at the negotiating table as well, and would suggest that that is possible. And this, I believe, puts our districts in positions to review what they want and agree what they want on quickly, but move ahead on things where change does need to be made. Thank you.
Okay. Any other debate on the motion? All right, seeing none, will Representative Pence.
Couldn't get the slide going.
Go ahead.
I'm still kind of confused as the whole thing. And what we've talked about some effects that we've had previously with evergreen clauses. They no longer exist. They're not in anything. I don't see how they make a difference now. Implied doesn't do anything. I still think that what we have currently, since it was removed, frees up the school districts to do what they want. We heard that we didn't want to put school districts, obligate them. Here in we turn around, we are obligating them. So it's kind of say, well, we don't want them obligated, but we're going to obligate them to do it every year. So I just don't think we need this particular legislation.
All right, any other debate on this motion? All in favor say aye.
Aye.
Roll call. Okay.
Representative Nielsen?
Aye.
Representative Shepard?
Aye.
Representative Bateman?
Aye.
Representative Boyle?
Aye.
Representative Gideus?
Aye.
Representative Clow?
I'm present.
Representative Gestrin?
Aye.
Representative Harris?
Aye.
Representative Orman?
Aye.
Representative Mendive? Representative Van Orden? Representative Pence?
No.
Representative Clock?
No.
Representative Engelking?
No.
Ward Engelking, sorry. Representative DeMordant?
Aye.
Okay.
So the motion passes. Representative Van Orden, would you be willing to carry this on the floor? Thank you. Next committee, we have Senate Bill 1149. And Karen, thank you for presenting this.
Thank you, Mr. Chairman and members of the committee. Senate Bill 1149 contains two elements that deal with collective bargaining. The First Amendment of this bill, found on page 1, lines 20 and 23, is clarifying language that make the section of the law easier to understand. Subsection 3, found on page 1, lines 29 through 35, sets out the first major element of the bill, that the local education organization must prove that they represent 50% plus one of the professional employees in order to negotiate. Subsection 5, found on line 39 through 41, states that the second major requirement of the bill, and requires that both the local education organization and the Board of Trustees must provide written evidence that their respective parties have ratified the agreement. I suspect there will be two questions as to why this needs to be done. Oh, I'm sorry. That was in another bill. After negotiations with the IEA, we changed the requirement to prove 50% plus one and made it permissive language. In other words, the requirement to prove representation only has to be done if the local school board requests it. In addition, if requested by the local school board, this proof must be provided annually. Section 33-1272, found on page 2, lines 3 through 24, clarifies some definitions and adds a definition. We clarify the definition of professional personnel by indicating that it does not include superintendents, supervisors, or principals. And we clarify that a local organization is 50% plus one of the professional employees. And finally, we define good faith bargaining. The amendment found in Section 33-1273, page 2, lines 37 through 41, clarifies who may negotiate. We believe the amendments in this bill will help foster accountability and transparency in collective bargaining. Proving majority support before a union is given the exclusive privilege of bargaining on behalf of teachers will help secure the climate of trust necessary for good faith bargaining. We ask that you send Senate Bill 1149 to the floor with a due pass recommendation, and I'm glad to stand for questions.
Thank you, Karen. Representative Ward Engelking.
Thank you, Mr. Chairman. Karen, when you say represent, you're not saying that they have to be members, are you?
Karen?
Chairman DeMore, not Representative Ward Engelking, no.
Okay. Thank you.
Representative Gestrin.
I don't have a question, Mr. Chairman, but I would make a motion to send Senate Bill 1149 to the floor with a due pass.
All right, thank you. We do have some testimony that is going to be offered, but I appreciate the motion. Any other questions for Karen before she sits down? All right. Bert, welcome to the committee.
Thank you, Mr. Chairman, members of the committee. For the record, I'm Bert Marley, the Director of Public Policy for the Idaho Education Association, and I'm here today to speak on behalf of our organization in opposition, and I'm sure you're shocked at that, in opposition to Senate Bill 1149. We do want to, thank all the stakeholders' involvement in this, creating a better bill than what we started with, but obviously we still stand in opposition to it. I want to talk about this kind of section by section, if I might, and just to point out some things that are of a concern to us. If you look at Section 1, Section 1 does two things. On the first page, line 29 through 35, requests by the board for written evidence of a 50% plus one majority for teachers association to be able to negotiate. We don't have a big problem with that. I find it interesting that we can't figure out what a majority is. We have to spell out that it's 50% plus one, but we don't have a problem with that. I do have a little concern about what written evidence is, because written evidence isn't defined anywhere, but that's okay. We can deal with that. Where the heartburn begins for us is the idea that it can be done annually or has to be done annually. Originally, it had to be done annually. Now it's done, it's permissive. The boards can require it to be done annually. And we really feel like this is an unnecessary hurdle. It's without value at best, and at worst, it's a form of harassment. I've just got to, this statement is based on 20 plus years experience as a negotiator in my school district when I was teaching. We had, I think in 20 years, two experiences where the board asked for proof that we represented more than 50% of the teachers, that we had a majority. And in both times, we went through the process, which is I've got to share with you, it's a complicated process and it takes a lot of time because it includes more than your members. You basically have to poll and talk to every single certified employee in the school district. You have that obligation to contact them and find out whether they want you to represent them or not. So it's a time-consuming process. You get a card from them, they sign it and say, yeah, you're the group that we want to represent us at the bargaining table. Now, doing that occasionally when it's a question makes a lot of sense to me because I think it is important that whoever is sitting at the table does represent a majority of the teachers. But to do it just as a ongoing yearly process is harassment because it takes volunteers a lot of time to get that in place. In the past, we were able to have those cards, good for a period of time. Now this would have to be done annually. And my experience tells me that when we've done that in the past, one time we got 96% of the teachers to support us, and the next time it was 97% of the teachers to support us. My other point is there's really not very many people out there that negotiate for teachers. There's other groups, but they refuse to negotiate. That's not one of their roles or one of the things that they even offer to do for school teachers. So in a way, it's almost moot. I think the issue is maybe more appropriate if professional employees, certified employees were to approach the board with a petition of, say, 20% of the teachers saying we're not happy with the group that's that's representing us, and then I think the board would be in a position to say we want proof. You know, because in reality, it's an issue for the teachers. It's not an issue for the board. The teachers need to decide who's representing them. You know, the board knows who's representing them. It's for the teachers to decide who represent them, and unless there's dissatisfaction expressed, this seems redundant and unnecessary. The second thing in this section on page 1, lines 39 through 41, it requires that we provide written evidence to each other that a majority ratification has occurred. It makes perfect sense, and we certainly don't have a problem with it, other than this is just another example of one case. You know, we've been doing this for years, and I remember every year after we get through negotiating, we'd go to ratification, we'd ratify the contract in most cases, and the board would meet and they would ratify the contract, and we'd contact each other. I'd pick up the phone, call the superintendent and say, we ratified it last night. You know, sometimes we'd share the vote, what it was, and he would indicate to us that it had been ratified by the board, and it was done. Well, because of one issue, to the best of our knowledge, that happened here recently, where a new local president had just been elected. The superintendent called her and said, you need to come down and sign the contract. So she went down and signed the contract, only to discover that it had never been ratified. And so then she had to back away from that and say, well, what hasn't been ratified, and it created a big stir. So here we are, you know, once again, passing legislation that just creates an added burden for everybody else in the state to solve one local problem somewhere. I do want to add at this point in time that because of the timing that we're looking at in all these other bills, that it's going to become more and more difficult for school districts or for local associations to ratify contracts, simply because of the timing. The June 10th timing, you know, it has to be ratified, I think, if I recall the date correctly, by about June the 20th. Almost anywhere in the state, teachers are off contract. They're, for all intents and purposes, unemployed. And they're out doing other things. And it's hard to get a majority together to be able to ratify a contract. And I think that's just going to be an ongoing problem that we're going to have to face. The timing of these things is going to make it very difficult for school districts to ratify contracts when school's out and teachers aren't in the area. Moving on to Section 2. Section 2 just simply excludes administrators from the bargaining process on line 12 and defines the term good faith, which we appreciate seeing in the legislation. Section 3 on page 2, lines 40 through 41, adds a sentence described as cleanup language that seems vague and unnecessary to us. We've asked a number of times for an explanation of why this language was changed, and we're never given a really good answer. The result, however, could be like what we've seen happen in Meridian, Middleton, and other school districts, where basically the school administration has told the teachers that they will no longer talk with them, but to talk to their attorney, who ended up being the only person sitting at the table when they went to negotiations. This concerns me, and I'll tell you why it concerns me. As somebody that's done this for 20 years, you know, you're concerned about the culture and the relationship that the administration and the board has with their teachers. If you're in conflict, if you're struggling to have respect for each other, if you insert a third person into that process, and I'm not saying having an attorney at the table is not valuable, but if the attorney is the only person sitting at the table, you have cut off communication for all intents and purposes between your teachers and between your administration and your school board. And, you know, I think that is probably one of the biggest concerns I have to this, because when we negotiated, we solved problems. Now, not everybody liked everything that happened. I certainly didn't, especially when it came to salary some years. But we sat down and we looked at the problems we had in the district and figured out how to make them work better. And when we moved to interest-based bargaining, it got even better. This idea of going in and just sitting across the table from an attorney is very discouraging. I think it's disrespectful and demeaning to teachers and has no place in the negotiation process. And so we feel like that's what this language does. What this provision provides is that negotiations can only take place between designated representatives. You know, you go through your attorney. It almost forces each side to name a designated representative and then only negotiate through them. If you look at that language again, it says negotiations shall only occur between designated representatives. It sounds like mandatory language to me. Had this bill been, had this bill originally agreed, I'm fumbling around here, I apologize, Mr. Chairman. Had this bill had a sunset, I think we could have been speaking in support of it today despite some of the concerns that I've expressed, because we were willing to try it out, we were willing to collect data and observe for abuse, but without the sunset, we feel that this bill needs to stay in committee, and we would appreciate you holding this bill in committee. And with that, Mr. Chairman, committee, I'll stand for questions.
Thank you, Bert. Questions for Representative Bateman?
Yeah, Mr. Chairman, Bert. When I started my teaching career, I was a member of the Idaho Education Association, but I eventually decided to drop out because of the requirement that if you're a member of the IEA, you had to be a member of the NEA, and that was because of certain radical, in my view, certain radical positions taken by the NEA, and the fact that it tended to support one political party. I decided to drop my membership, and I found that a lot of my colleagues, many of my colleagues, dropped out for the same reason. And I'm just wondering, I hear rumors today that in some districts, fewer than 30% of the teachers are actually members of the Idaho Education Association. Is that correct? Would there be that low number in some districts?
Bert?
Mr. Chairman, Representative Bateman, I can't answer that question directly because I don't know the answer to it. Although I can easily imagine that there are districts out there that have less than 50% of the members or less than 50% of the teachers are members, and it could be as low as 30% in some districts. In other districts, it's as high as 95%. So, it does vary, and that's why this law, I believe, is written not to require membership to be at 50% plus one, but that they represent 50% plus one of the teachers in the state. And I think that's incumbent on us as a right-to-work state that we have that obligation to represent all members of the profession, whether they're members or not.
Okay. Representative Nielsen.
Thank you, Mr. Chairman. Excuse me. Bert, there are some districts where the IEA is either not very well represented and et cetera. What is to stop the other teachers from forming and organizing and electing their people to represent them so that they could be those people mentioned in this respective designated representatives? Isn't that quite possible?
Bert.
Thank you, Mr. Chairman. Representative Nielsen, that's absolutely possible, and it certainly happened in the past. It hasn't happened often, and it hasn't been sustained for very long, because if you know anything about negotiations, it's hard work. And occasionally a group of educators would get excited and dissatisfied, and they decided to do that very thing. That's the system. That's that 50% plus one. I'm just here to tell you that it doesn't happen very often, and it tends not to be terribly successful based on past experience, because it's very difficult work and it takes a lot of time and effort to represent people at the negotiation table.
Okay. Representative Ward Engelking.
Thank you, Mr. Chairman. And Bert, currently, though, they can do that. In fact, I think I know a couple of locals that currently do negotiate without the help of, or the representation of the IEA. Is that correct?
Bert?
Mr. Chairman, Representative Ward Engelking, that's absolutely correct.
Okay. Seeing no more questions, Bert, appreciate your testimony.
Thank you.
Committee, that's everyone that we have that is signed up to testify on this legislation. And I don't see anybody else jumping up to do so. So we have a motion before us, and that is to send Senate Bill 1149 to the floor with a due pass. Debate on that motion. Representative Nielsen.
Thank you, Mr. Chairman. It's my understanding, doggone it, my wife gets after me about this coughing and snorting in public. She'd be here today, I'd really catch it. It's my understanding that there's another organization that teachers can belong to, and it's Northwest Education, something or other. And I'm of the idea that there are districts that could employ that organization to work for them and represent them in negotiations. I don't know if this is happening or not, but that is a distinct possibility. And the fact that they can organize amongst themselves where they don't have, where the IEA doesn't have a 50% plus one, that's possible also. So I think we've got a good piece of legislation here, and I will support it on that basis.
Thank you. Karen, I did not give you the opportunity to close, and I should have. Did you want to make any closing comments?
I just answer questions if there are any.
Okay. Was there any questions for Karen? Representative Gideus, did you have a question for Karen? No. Okay. Representative Harris has a question for you, Karen.
Hi, Karen. On that page 2, lines 38 through 41, I see the word changes, but reading it, it seems almost the same in terms of meaning, unless there was a purpose for changing that verbiage. What might have been the reason for changing the verbiage there?
Mr. Chairman and Representative Harris, thank you for that question. Actually, the line we struck out has one letter that makes it different, and it's on line 30 where we talk about matters covered by the negotiations agreement.
Your line
39.
Oh, 39. Okay.
Yeah, I'm sorry. So the negotiations agreement was actually the agreement that set out how they were going to negotiate. It wasn't the negotiated agreement, it was the negotiations agreement. So it set out how they were going to conduct their negotiations. Those all went away with students come first, so we struck that sentence. And that's why we added the second one, just to say that each party will appoint representatives, whoever those are, to negotiate on their behalf.
Okay, any other questions for Karen?
No.
Representative Ward Engelking.
Thank you, Mr. Chairman. Karen, do we currently have districts that use attorneys and do not use administrators and school board members at the table?
Chairman DeMordaunt, Representative Ward Engelking, yes, we do.
Okay. Follow up on that. Are they the only ones that are at the table?
Representative or Chairman DeMordaunt, Representative Ward Engelking, I can't answer that question. I don't sit at those tables, so I don't know.
Okay, thank you.
Thank you, Karen. So we now have back before us, I apologize for that misstep there, committee, but we now have back before us this motion. So debate on the motion. Representative Pence.
Thank you, Mr. Chair. Just a little clarification and something that's been mentioned earlier. The Northwest educators do not negotiate, and that was mentioned earlier. They don't want to get involved in negotiations, from what my understanding is. So,
that was my recollection as well, Representative Pence. Representative Gideus.
Chairman, just further clarification on that. Northwest professional educators, they'll bring in support services to teachers who want to develop a local-only teacher association for negotiations.
Thank you for the clarification. All right. Any other debate on that motion? Motion to send to the floor. Right, then we'll vote. All in favor say aye.
Aye.
All opposed say nay. Okay. Would all three of you like to be recorded? All right, thank you. The motion passes. And Representative Gestrin, would you be willing to carry this to the floor? Thank you, sir. Committee, that is everything that we have before us at this point in time. Right now, we will plan on meeting tomorrow at 9 a.m. I just watch your email and listen to confirm that one way or the other. And then also remind you about our little get-together tomorrow evening as well. With that, is there anything else that needs to be brought before the committee at this time? Seeing nothing, then the committee will stand adjourned until 9 a.m. tomorrow. But again, that is essentially it's at the call of the chair. All right? 9 a.m. tomorrow. Thank you very much. We go on the floor at 10 for your information.
Welcome to Idaho in Session, Legislature Live. Idaho in Session is sponsored by the Idaho State Broadcasters Association, the J.A. and Catherine Albertson Foundation, Union Pacific Foundation, Idaho Association of Counties, Idaho Cable Telecommunications Association, Association of Idaho Cities, and your contributions to the Idaho Public Television Endowment. Welcome to Idaho in Session, Legislature Live. Idaho in Session is sponsored by the Idaho State Broadcasters Association, the J.A. and Catherine Albertson Foundation, Union Pacific Foundation, Idaho Association of Counties, Idaho Cable Telecommunications Association, Association of Idaho Cities, and your contributions to the Idaho Public Television Endowment.